Good morning, everyone. Virgo here. It is September 15th, 2020, and once again, happy Tuesday morning. Okay, so I have a piece of information that is rather important. I think you guys will have to probably reach back a little ways to remember this person. Some of you are going to recognize him right off the bat. So back several months ago, I did a Snoop for Truth with Snoop with regards to a gentleman by the name of Rod Class. Now, Rod Class has been on YouTube and across social media for quite some time. One of the things that he is very well known for is the right to travel argument. And although he's never come up with a winning solution with regards to that, that is probably one of the things he's most famous for. I also did a sovereign citizen history video on him about 6 months ago. Now, Rod has returned. His feature this time is to be a private attorney general and a constitutional bounty hunter. It doesn't end there. He has decided that he is going to run seminars and webinars again. And the beginning of these starts October 16th, which is a Friday, in the Houston, Texas area. He's charging around $800 per ticket, and these seminars are live. I'm warning people about this simply because this particular person, if you actually do some real research on him, is not only a felon and has a very, long history of crimes behind him, but in addition to that, he's been virtually wrong about literally everything he's ever said or tried to teach, even on a YouTube video. So spending $800 to go and see him live and in person at a seminar is a bit much, in my opinion. I'm going to go ahead and link the right to travel part of the video that Snoop and I did together to remind you of the claims that Rod has made in the past and some of his history that I think you'll find important. With just 31 days to go for his live seminar, Rod is really hoping to be able to gather as much of those fiat notes as possible. And I'd like to put a stop to that because, after all, Rod Class is not only a felon, but he's also a con artist. Good morning, everyone. Virgo here. It is August 7th, 2019, and welcome to Snoop for Truth Wednesday. Today we're going to be going over part 3 of Right to Travel, and today has a lot to do with another amateur legal theorist by the name of Rod Class. Now, a lot of people have already heard of Rod. I've spoke about him in Sovereign Citizen History quite a bit, and we have talked about some of the hoaxes that he has pulled in the past on Snoop for Truth. But today, we're going to heavily go into a lot of the claims he makes with regards to right to travel. Here's Rod in his own words on several different videos, making some claims that just simply don't pan out to be true. Take a listen.
Hello, ladies and gentlemen. This is Rod. This is Saturday night, and we're having a private call here. We didn't make it last Friday night. Internet was down. So, but I want to have a call here tonight. There seems to be some misunderstanding on what we're doing in this traffic case in North Carolina. What is the big picture on this traffic case? This is not just about the driver's license. It's not just about the CDL or the commercial motor vehicle license. It's just not about that. It is the extent to the fraud that the courts will go to in order to sit here and cover up their corruption. Why the court, and it says, including a petition for review of administrative actions. So for you to try to go back out and maybe just use this Title 28, 1631, transfer to Tier 1 of jurisdiction, if you're not dealing with an administrative issue here, they could sit down and play with you on this. Because whenever a civil action is filed into a court as defined in this section 610, and I told you what the courts were, you got to make sure that you're in the right court, which falls under this section. So now we're coming back in, we're responding. Now, what we're coming back in and explaining to him is prior to my ticket, back in July, around the 14th, I sent a private contract into the Department of Transportation addressing the driver's license issue and separating myself from their United States, standing in the light side of this thing. I sent them a contract. I sent them a proposal. I sent them in my license plate, the title, removing it. They held onto that contract. They held onto that plate until it expired, knowing that they was going to put me in a bind of not having the usage of my truck. Got accountability here. This thing is not just about the driver's license. The fact that we can prove it now, because right now, as it stands, everybody in this country, if you will understand my paperwork, and you will take the time to comprehend the paperwork, and get rid of the narrow-mindedness of some of what you're doing here. Get out of the box. At this point in time, the hearing that I had last Monday, with what happened and transpired in it, this judge in Raleigh has 5 choices. 5. That's all he has. 1, if he remands it back down to the administrative court saying, hey, these are public offices, Mr. Class did bring it into the right court. The prosecutor, the Attorney General's office, never rebutted the laws. They never rebutted the facts or the conclusions. The Attorney General's office is that we are not public officials. We're private contractors. As for improvement of motor carrier safety and the enforcement of regulations, standards, and orders of the United States government, not corporation, United States government, on commercial motor vehicles, hazardous material, transportation safety, compatible state regulations, standard, and orders, state plan of procedures and content. The Secretary shall prescribe procedures for a state to submit a plan under which the state agrees to assume responsibility for improving motor character safety and adopt the enforcement regulations, standards, and orders of the government on commercial motor vehicle safety. And ladies and gentlemen, that's exactly what we're doing. We're exposing. We're opening up the door. The paperwork is out there. All you have to do is understand the paperwork. All you have to do is comprehend what we're doing and get out of your box.
In addition to his video claims across YouTube, he also has a blog called sovereigncitizenblog.blogspot.com. And if you actually take a look in the description of this video, you'll find that this link is there and will take you to this blog. And as you see, the very first thing that pops up is the driver's license scam by Rod Class. Talks about how he believes that driver's licenses are scams and how he's going to get into the nuts and bolts of the right to travel issue. So, again, more bogus claims by Rod Class. For a little more ridiculousness, you can head on over to his Scribd account, which shows you a contract on driver's licenses uploaded in 2011. This makes the claim that since he is a private postmaster of some sort, that he can actually tell anybody that pulls him over or anyone who tries to take him to court with regards to an actual traffic infraction that he can sue them for trying to pull him over. As you see in this paragraph here, it reads, in the event that one of your agent's employees or contractors of any of the franchised administrative agencies of the United States should restrict the liberties of Rodney Dale class, you hereby agree to provide compensation in the amount of 1 troy ounce of 9999 gold or gold coins for every 60 seconds said liberties are restricted. Ladies and gentlemen, let me give you some background regarding Rod Class. Rod Class is a functionally illiterate amateur legal theorist with barely a high school education who has lost every single case in which he has ever been involved, over 76 consecutive losses in a row and still counting. Further, Class has a long history of psychiatric problems involving delusions, pathological opposition defiance of authority figures, and pathological lying. Moreover, Class is a multi-convicted, weapons-related convicted felon who also has several additional misdemeanor convictions as well. Because of Class' well-publicized hatred of our elected representatives, their appointees, and our Republican form of government, because of his history of psychiatric problems, and because of his lengthy criminal history involving deadly weapons, Class has been placed on the United States Terror Watch List. Most importantly, Class is a professional hoaxer and charlatan who is behind a number of legal hoaxes which he created and peddles to intentionally defraud the American people. For an entire series of hoaxes by Rod Class, there will be a link in the description that you can take a look at for yourself. Okay, ladies and gentlemen, let's start with the first hoax. Rod Class and other amateur legal theorists falsely claim that a person is not required to have a driver's license to drive a motor vehicle on the grounds that every person has a, quote, right to travel. Thus, Rod Class and other amateur legal theorists mistakenly believe that the, quote, right to travel is the same thing as the, quote, right to drive a motor vehicle without a driver's license. But this is not so. The real truth is that the right to travel is merely the judicially recognized right to leave one state and enter another state and be treated like any other citizen of that other state. Let me say that again. The truth is that the right to travel is merely the judicially recognized right to leave one state and enter into another state and be treated like any other citizen of that other state. It's your right to mobility, meaning that if I leave California and go into Arizona, I have the right to do that and be treated like any other citizen of Arizona. Period. That's it. It isn't about right to drive an automobile in any way, shape, or form. Right to travel has nothing to do with driving. Has nothing to do with driving anything either. Under the law, there is no such thing as a, quote, right to drive a motor vehicle without a driver's license. But Rod Class and other amateur legal theorists do not know enough to even realize this. Now let's talk about hoax number 2. Rod Class and other amateur legal theorists point out that under federal law, a person is not required to have a driver's license to drive a motor vehicle unless that person is engaged in interstate commerce. Okay, so what I've done is brought you over to annenbergclassroom.org to the Guide to the United States Constitution, Article 1, Section 8. We're going to go to Clause 3, which reads, to regulate commerce with foreign nations and among the several states and with the Indian tribes. This is what is called the Commerce Clause. And as you see here, which will be linked in the description of this video, the Commerce Clause refers to Article 1, Section 8, Clause 3 of the United States Constitution, which gives Congress the power to regulate commerce with foreign nations and among the several states and with the Indian reservations. If you want to read more about the Commerce Clause, this link will be in the description, as I said. This clause authorizes the federal government only to require driver's licenses only for drivers engaged in interstate commerce. Here's the truth. But what Rod Class and other amateur legal theorists do not know is that state law also applies to the same person at the same time. This is because under the 10th Amendment, state law governs the subject of driver's licenses outside the context of interstate commerce. Let's take a look at the 10th Amendment. Okay, so we are over here at the Constitution of the United States of America, 1789, and we have the 10th Amendment up. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. And as everyone knows, under state law, a person is required to have a driver's license to drive a motor vehicle when that person is not engaged in interstate commerce. So when both federal law and state law are combined and applied to the same person at the same time, a person is required to have a driver's license to drive a motor vehicle in all contexts, all the time, no matter what, whether or not that person is engaged in interstate commerce. But Rod Class and other amateur legal theorists do not know enough to even realize this. It appears as though Rod and many others misunderstand the federal law. Rod Class mistakenly believes that federal law governs every legal subject. This is precisely why he pretended to be a retired federal judge in the, quote, Judge Dale forgeries. Why he only cites federal statutes in support of his false claims, and why he uses the phrase congressional, meaning federal intent. Class does not know that federal law only governs that tiny list of legal subjects that were expressly delegated to the federal government in the U.S. Constitution, and that under the 10th Amendment, state law governs everything else, including driver's licenses for those who are not engaged in interstate commerce. Let's read this again. The 10th Amendment says, the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states, respectively, or to the people. This means that almost all of the law in our country is state law, 95 to 99% multiplied by 50 states, not federal law, which only governs a very tiny list of legal subjects. Note that if the law really was, as Class mistakenly believed it to be, federal law governs every legal subject, there would be no need for state law in the first place, and the 10th Amendment would be absolutely meaningless. Class makes this amateur mistake about federal law because he misunderstands the, quote, Supremacy Clause in the U.S. Constitution. Class mistakenly believes that federal law governs every legal subject and therefore mistakenly concludes that under the, quote, Supremacy Clause,
federal law is always supreme over every legal subject in the law. But this is not so. Unknown to class, under the Supremacy Clause, federal law is only supreme to state law if and only if there is a direct conflict between federal law and state law in the same exact legal subject. But such direct conflicts between federal law and state law on the same exact legal subject are extremely rare because federal and state law govern entirely different, most of the time opposite, legal subjects. So when there is no direct conflict between federal law and state law on the same exact legal subject, which is almost all of the time, state law is supreme as to all state law legal subjects, such as driver's licenses for those who are not engaged in interstate commerce. So for a detailed explanation of how totally irrelevant the commerce actually is to state driver's license and traffic regulation and law, see the second comment in the thread on Avalon, projectavalon.net that I'm looking at right now. I will post this in the description of this video if you want to read it. Also, though, you can go back to Snoop for Truth, Right to Travel Part 1, and that information is also in that video. So listen, guys, the actual real law itself on the subject of driver's licenses and the right to travel, over a century ago, the Supreme Court held that the states had the right to require all drivers of all motor vehicles to have driver's licenses, whether or not the driver was engaged in interstate commerce. But Rod Glass and other amateur legal theorists do not know enough to even realize this. Here we are back over at Hendrick versus the state of Maryland, and this will actually be located in the description of this video, in addition to, I believe, one of the other videos, because we have gone over this case before, so you would find this in one of the other Snoop for Truth videos also, and also a couple of the Virgo Triad videos that were done before we started Snoop for Truth. This is one of those cases that pops up often in this argument, it seems. In this case, if you recall, the United States Supreme Court held that a state may rightfully prescribe uniform regulations in respect to the operation upon its highways of all motor vehicles, those moving in interstate commerce as well as others not moving in interstate commerce. And to this end, the state may require the registration of such vehicles and the licensing of their drivers. This is but an exercise of the police power uniformly recognized as belonging to the state under the 10th Amendment. In the 8th paragraph, at about 70% through the text, this decision is from the highest court in the United States. This court is the only court in the United States which has the power to overturn this decision, but it has never done so. That means this decision is still the single controlling law on this subject in every single state and federal jurisdiction in the United States. So if you find any decision from any court anywhere in the United States which contains any language of any type which you interpret as preventing the United States or the states within the United States from requiring drivers of motor vehicles to have driver's licenses, then you have interpreted that other decision wrong. I have highlighted the section for you so that you can read it for yourself right here online if you'd like, or you can use the link in the description to take a look at it for yourself. There has never been any decision from any court in the United States which holds that states may not require drivers of motor vehicles to have driver's licenses. But even if there were such a decision, this decision you're looking at right now would overturn it. Since this decision, Congress, in compliance with this decision and in compliance with Article 1, Section 8 and Clause 3 of the U.S. Constitution, passed national federal legislation regulating only those drivers who were engaged in interstate commerce. Title 49. Under the 10th Amendment and under this decision that you are looking at, this reserved unto the states the power to regulate only those drivers who were not engaged in interstate commerce. In this sense, the federal law and state law are now opposites of one another, but Rod Class and other amateur legal theorists do not know enough to even realize this fact. Under the 10th Amendment, the states have the constitutional right to require driver's licenses of all drivers who are not engaged in interstate commerce. In State versus Sullivan, which you see on your screen in front of you, in this case, the court held the 10th Amendment to the Constitution of the United States provides the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states. Within this reservation of powers to the individual states is what has been judicially termed the police power. Such, state may rightfully prescribe uniform regulations in respect to the operation upon its highways of all motor vehicles. And to this end, it, meaning the state, may require the registration of such vehicles and the licensing of their drivers. This is but an exercise of the police power uniformly recognized as belonging to the states under the 10th Amendment and not belonging to the federal government under the 10th Amendment. Quoting the Supreme Court case that you are actually looking at, at the 8th paragraph, at about 45% of the way through, you can take a look at this link and you will see that the state law governs the requirement of driver's licenses for all vehicles and drivers not engaged in interstate commerce. Okay, and I have that highlighted for you here. If you would like to take a look at it on the screen, just simply hit pause and you can read it for yourself. Okay, in our next case, which is going to be linked to the description of this video also, in this case, the court wrote the United States Supreme Court has long held that states have the right to regulate the use of state roads by requiring drivers on those roads and obtaining driver's licenses, carry liability insurance, and pay taxes and fees, and that such regulation does not violate the Constitution. In the absence of national legislation covering the subject, a state may rightfully prescribe uniform regulations necessary for public safety and order in respect to the operation upon its highways of all motor vehicles, those moving in interstate commerce as well as others not moving in interstate commerce, and to this end the state may require the registration of such vehicles and the licensing of their drivers. This is but an exercise of the police power uniformly recognized as belonging to the states under the 10th Amendment and not to the federal government, and essential to the preservation of the health, safety, and comfort of their citizens. Quoting the Supreme Court case you are looking at right now, 31st paragraph, 75% of the way through, and I will highlight it for you. I have highlighted the start of this section, so you are welcome to pause the video and read it for yourself, or you can use the link in the description. In our next case, it is L versus Richmond Police, and in this case, the court wrote the Supreme Court has held that states may constitutionally regulate the use of public highways. In Wrights versus Mealy, the Supreme Court stated, The use of the public highways by motor vehicles with its consequent dangers renders the reasonableness and necessity of such regulation apparent. The universal practice among the states is to register ownership of automobiles and to license their drivers. Any appropriate means by the states to ensure competence and care on the part of its drivers, licensees, and to protect others using the highway is consistent with and means complies with due process. And contrary to what Rod Class and other amateur legal theorists mistakenly believe, the Supreme Court did not limit its holding about driver's licenses to commercial uses of public highways. At the 13th paragraph of this case, at about 70% through the text, you can find more information with regards to this. I will highlight it for you. I have highlighted the start of the paragraph for you. You're welcome to pause the video and take a look at it for yourself if you'd like, or you can use the link in the description for this court case and read it complete in its entirety for yourself. There is no such thing as the unregulatable right to drive without a driver's license. There is no such thing. No such thing. Next, we're going to Commonwealth versus Ascenzi. In this case, the court held there is no right to drive recognized by the U.S. Constitution or by any state constitution because there is no constitutional right to drive. Driving may be regulated, licensed, or prohibited entirely, beginning in the second paragraph to last paragraph at about 95% through the text. The right to travel is not the same thing as the non-existent right to drive a motor vehicle without a driver's license. I will go ahead and highlight that section for you. I have highlighted the beginning of this statement for you. You're welcome to pause the video and read it now for yourself if you'd like to, or of course, you can find the link in the description of this video. Let me stop right here and just mention to you guys that the reason why I continue to go over these cases is because with every single Snoop for Truth video that I do, I get a multitude of nasty comments claiming that we have no idea what we're talking about. And the truth is, we have every idea what it is that we're talking about. Snoop has been doing research like this for a very, very long time. One of the reasons why we are bombarding these idiots with this information is because there simply is no way to rebut against it. There are way too many cases that involve sovereigns trying to prove that they have right to travel when they really have absolutely no idea what they're talking about. So many cases. And that's why when I do these videos, there's a massive amount of information and case law involved, because you guys need to see how many times these people get proven wrong. As a matter of fact, there may have been a few cases that were dismissed, but they weren't dismissed because it was a win. They were dismissed for another reason, like a cop not showing up to a traffic case. I have not ever been able to find case law that shows me anyone with the right to travel argument that has ever won a case. I've heard lots of people claim it, but no one can ever show me an actual case. The next case, we're looking at State versus Sullivan. In this case, the court held although there is a well-established and fundamental right to interstate travel, there is no corresponding right to operate or drive a motor vehicle, showing that the right to travel is not the same thing as the alleged right to drive a motor vehicle. Here is no right to drive an automobile on the roads and highways. The courts have universally agreed that an individual does not have the right to operate or drive a motor vehicle. Driving on the roads of the state is not a right, but a privilege. And at the second to the last paragraph, at about 65% of the way through the text, It states the right to travel is not the same thing as the non-existent right to drive a motor vehicle without a driver's license. I will take you to that section and highlight it for you. Okay, I've highlighted the beginning of that section for you, so you're welcome to stop the video, pause it, and take a look at it for yourself, or use the link in the description. Next, we're taking a look at John Doe versus Georgia Department of Public Safety. In this case, the court held that there is no such thing as a right to travel and cited the following holding of another case with approval. There is no fundamental right to travel. The court also cited this holding from another case with approval. While a fundamental right to travel exists, there is no fundamental right to drive a motor vehicle, showing that the right to travel is not the same thing as the alleged right to drive a motor vehicle. At the fourth paragraph from the bottom, at about 85% of the way through the text, we will show that the right to travel is not the same thing as the non-existent right to drive a motor vehicle without a driver's license, and I will highlight that for you now. Okay, I have highlighted the start of that discussion and statement made by the judge, so if you would like to pause the video and take a look at it, you're more than welcome to do that, or you can use the link in the description and look at it for yourself. In our next case, the court held, although the U.S. Constitution recognizes a right to travel interstate within the United States, referred to as the right of free movement between the states, the Constitution, does not recognize a fundamental right to drive, drawing a distinction between these two different legal subjects, entitled due process. At about 80% through the text, you will see that the right to travel is not the same thing as the non-existent right to drive a motor vehicle without a driver's license, and I will take you to that citation now. I have highlighted the beginning of that section for you, so you can pause the video and read it if you would like, or you can use the link in the description. In our next case, we're looking at Matter of Allen versus New York State DMV, and the same holding verbatim at the second, entitled Due Process. At about 80% through the text, you will see that the right to travel is not the same thing as the non-existent right to drive a motor vehicle without a driver's license, and I will highlight that text for you now. You're welcome to pause the video and read this if you would like to, or you can use the link in the description. We're now over here at Matson versus New York State Department of Motor Vehicles, and same holding verbatim at the section entitled Due Process. At about 80% of the way through the text, we will show that the right to travel is not the same thing as the non-existent right to drive a motor vehicle without a driver's license, and I will highlight that text for you now. I mean, it's amazing, isn't it, guys, how many times this is actually repeated to show that there's an absolute distinction between right to travel and driving without a driver's license. And yet the argument still persists, yet we still see all of these videos with people getting pulled over by cops and making crazy SovCit claims. All right, I've highlighted the section for you under due process. That's the beginning of the section. You are welcome to pause the video, take a look at it, or you can look at the description at the link. Okay, so now we're over here at Matter of Gilman versus New York State Department of Motor Vehicles, and the same holding verbatim at the section of due process. So are you guys seeing a trend here? Seriously. You know, I mean, it's stating exactly the same thing, every single time, because there are so many instances where this is popping up in the courts, and the courts have to say, hey, no, right to travel is not the same thing as the right to move freely. It's absolutely ridiculous that people actually continue with all of this information out there debunking it to rely on the right to travel argument. It simply does not exist in reality. It is made up. It's a complete hoax, and people like Rod Class and other individuals that copy these SovCit groups and lone wolves that are out there making these hoaxes are getting people into gobs of trouble. So there you go. I've highlighted it once again, but yet again, this is verbatim to the other two cases. We're going to go ahead and move on to a couple more cases here, but then I'm going to link some extra ones for you guys in addition, so that you can look at those if you'd like to. There is no, we're not running out of cases to prove right to travel is not something that's a legitimate argument. You must have a driver's license in every single state within the nation. Period. End of story. And this could continue on. We could make more videos about this. But to be perfectly honest with you, there's those that are just not going to listen. But I'm hoping that we'll catch some of those that are on the fence so that they have the opportunity to see how many pieces of case law there actually are out there that are not cherry-picked, that actually show and say you must have a driver's license, and right to travel is nothing, has nothing to do with driving without a driver's license. This is Jones versus Helms. In this case, the Supreme Court of the United States held the right to travel is the right of a United States citizen to travel from one state to another and to take up residence in the state of his choice and to be treated like any other citizen of that other state. At the 8th paragraph, at about 25% of the way through the text, this will show that the right to travel has nothing to do with driving anything. Instead, the right to travel is all about being treated the same as the local state citizens, regardless of which state you happen to be in. I'll take you down there now. And I have highlighted that section of the case for you. You are welcome to read through it and pause this video, or you can look in the description. Now, let me just say to you guys that there are several more. And I'm going to link all of those in the description of this video for those of you that actually want to go through and read every single one of them. But there are so many that if I read all of them out, it would probably take about 3 hours to get through this part 3 of this video. So what I'm going to do is leave this here and let you guys research for yourself if you want to. I want to thank Snoop for all of your wonderful research. This has been an incredible 3-part series that Snoop did on right to travel and driving without a driver's license hoax. I want to mention again that people like Eddie Craig and people like DALE Class are hoaxsters. They're people that really have no idea what they're talking about. Their claims of being federal judges, etc., are all bogus. We're talking about people like Anna Von Reitz, people that claim that they're judges and all these other things. Anthony Williams, who claimed that he was a private attorney general. These individuals are people with an agenda, and their agenda is not for your best interest. There is gobs and gobs of proof that show that you cannot legally drive without a driver's license. And all you have to do is read the 10th Amendment to see that the states have the right to regulate the traffic, roads, and licenses of people in their state. In addition to that, let's not forget that the Constitution might need to be read too. After all, it's the Constitution that states freedom of movement from state to state. There's nothing in the Constitution that says right to travel. And there's certainly nothing in the Constitution that says you have the right to drive an automobile or operate a motor vehicle without a driver's license. Once again, I want to thank the awesome Snoop for Truth for all of this wonderful educational information, all of the great case law, and proving once again that the facts matter. Have a wonderful day, everyone.